Welcome to FromRome.info. I am Brother Alexis Bonillo, the publisher of that electronic journal, which features news about Rome, Italy, the Catholic Church, and the Vatican. This is why the election of Leo XIV is invalidated by the papal law of John Paul II, Part 2. In Part 1, I explain simply why allowing 133 cardinals to vote caused that conclave to become incapable of electing anyone in a valid way. In this Part 2, I'm going to get into the nitty-gritty because I've done some more research and found out it is even worse than I said. Okay. Because there are some commentators who said, well, the cardinals have the right to interpret, and so your interpretation doesn't mean anything. And we'll see that I am not interpreting, and they didn't either. Okay. So I ask you to look at the documents, and don't believe what I say. Check it out. So the name of the papal law is Versione Dominici Gregis, and you can find it at the Vatican website in many languages. Look at the English, and then if you know the Latin, pull up the Latin, because the Latin is the only legal text. The other translations, which are inaccurate, if you follow them, you will violate the law because they don't express exactly what is said in the law. And the cardinals are obliged to follow this law because the last three paragraphs of this law, where John Paul II promulgates it and makes it a law, the second paragraph has a clause that is very significant because it says when the election is not valid. And how do we know it? It says, I declare that anything done contrary to this law by anyone of whatsoever dignity, knowingly or unknowingly, is irrita. The English is going to say is null and void, but the Latin is irrita, which is a technical term meaning must be considered never to have been done. Okay, so it's talking about actions. And obviously, persons of whatever dignity refers even to cardinals. Okay, so this is why the election is invalid, because the cardinals did something that's contrary to the law. They allowed 133. Now, in number 33, in paragraph 33 of Versione Dominici Gregis, it says clearly that the maximum number of cardinal electors shall not exceed 120. The English says must not exceed, and that's an incorrect translation because must is used to translate the Latin verb oporteat. And the Italian translation says should not, but dovere is not in the Latin. The Latin text is ne excedat, which is a negative subjunctive in Latin. And in the history of the Apostolic See, in their jurisprudence, a negative subjunctive command, that's called a hortatory subjunctive, is an equivalent precept. That means it has the force of a formal command, but it's equivalent to a force of a formal command, but it's expressed in other words. So that establishes a law. There's 120, and that's maximum. And if we're going to interpret a law, an interpretation is only valid if it's authentic. And authentic means that the interpretation must come from the proper authority and read the law the way the legislator has intended it to be understood. Now, there are cases in which you can't appeal to the authority to interpret the law. For example, in the death of a monarch and he has a last will and testament. Or a papal law in conclaves, because there's no pope. A conclave is held when popes are either dead or have resigned validly. They're petra nudis. So first, a little digression on the proper interpretation of law. And I know many lawyers watch and are fans of From Rome. So if you catch me in anything, leave a comment. So St. Alphonsus Auxiliary, doctor of the church, who had a doctorate in utriusque, that is, in civil and ecclesiastical law, he wrote a tract on the interpretation of law, and you can find it in his Theologia Moralis, which was published in many editions. The 1905 edition is really good. And in his treatise on how to interpret law, he explains that an interpretation of the law is an explanation of the text of the law using other words than the words used in the law. And he'll cite this example of the last will and testament of a king who leaves a certain amount of money to all his sons. And he uses the Italian figli, which can mean sons or daughters. Okay. However, a question rises, the monarch's dead, how about his illegitimate children, that is, his natural children? What does this term figli mean? Does it mean only natural children or all his legitimate children? And St. Francis says that it's always the children of his first wife or second wife. So St. Francis says the authentic meaning of the law is what the term is presumed to mean in the context in which the document was written. And it was a Catholic king. He's talking about the king of Naples. It's the 18th century. Sons and daughters means legitimate sons and daughters. To interpret it as natural sons and daughters so that even his illegitimate children could benefit could not be done by the heirs. The next king, the one who succeeds the king as monarch, he alone could interpret it. Okay? Because in a monarchy, only kings can interpret the laws of kings, especially the last will and testament, unless that authority has been granted to some other body. So that's an example of how to interpret the text. So it is said that the cardinals use their power of interpretation to read 120 and say that that rule doesn't apply anymore, it's 133. And here's the argument against that. If you change it from 120 to 133, you have changed the law. There's no doubt about it. You can't argue you haven't because 130 is not 120. And when the clause says, let the maximum number not exceed 120, that is a clear precept forbidding what the cardinals did. So that means what the cardinal did is contrary to the law, and therefore it is irrita by the promulgatory clause of Universi de Medici Gregis. So the cardinals, it's argued, have the authority to interpret the law. Yes, in number 5, they are granted authority to authentically interpret the law if there arise doubts or controversies. Okay. The first problem with this claim is, on the 30th of April, Vatican News published an announcement claiming that the cardinals voted unanimously to claim they could 133 could vote. So before I get into the text of what they claimed and their reasoning, the first problem of this is a problem of fact. Because according to Vatican News, all the cardinal electors arrived at Rome on May 5th. But this declaration was issued on April 30th. And if you go to number 5 in Universi de Medici Gregis, you'll find that for the interpretation to have force of law, all the cardinal electors must agree. Not just if 5 didn't agree, if 5 weren't asked to vote, it has no value. So their declaration on April 30th has no juridical value. There's no way you can appeal to that. But let's hypothetically say that once they all got together inside the conclave, they voted again and they confirmed that. We have no evidence of that. And therefore, you couldn't argue it in a court of law that there's such evidence. Okay. But even if we look at their argument, we find that it is invalid for many reasons. First of all, they claim that Pope Francis dispensed them of the rule of 130. The problem with that claim is a dispensation from Pope Francis to violate a formal precept in a papal law which has a clause declaring null and void anything done contrary would require Pope Francis to have written the declaration and published it in the Acta Apostolic Sedis, and no such document has ever been claimed to exist. The second problem with this claim is the mere fact that he created 133 is equivalent to a dispensation. Well, the problem with that is that this law was passed in 1996, and Pope Francis is not the legislator. John Paul II is. And I confirmed this in 2019 when I spoke to the secretary for the dicastery for the interpretation of legal texts. And he says the legislator is not the living pope. It's not the pope, the previous pope during its sede vacante. It's not the previous pope that resigned or died. It's the one who wrote the law. The only way you can appeal to the present pope to be the interpreter of law is if he's alive and validly elected. So they can't do that because Pope Francis was dead. And you can't appeal to Pope Francis because you have to argue from the intentions of John Paul II. Now, John Paul II said that the number is 120. In the beginning of his law, he explains why he chose 120 quite clearly. He says, I'm choosing 120 because it sufficiently represents the universality of the church. And he's probably drawing the idea from the Apocalypse where it says the heavenly city has 3 gates on each of its 4 sides. So he's thinking of 10 cardinals for each gate, 120. Okay. But he uses the Latin word satis to say that the number is sufficient. Now, if 120 is sufficient, there's no necessity of more. And therefore, John Paul II clearly does not permit an authentic interpretation of the precept in paragraph 33 to mean anything more than 120. You can't even go there, okay? So their claim of a dispensation is false. Their claim that the cardinals voted on it and has legal force is false. Their claim of the rationale of being dispensed is false. Their claim that naming cardinals creates the equivalent of a dispensation is false because all these cardinals were created after 1996. And therefore, when the Pope was creating cardinals to vote according to a papal law that's already been published that says only 120, you can't claim he's creating cardinals to violate that law unless he changes the law or dispenses from the law by a written document. You have to understand the creation of cardinals merely to provide for a sufficient number of cardinal electors to participate. And the next day, Vatican News, seeing this discrepancy, ran an article claiming, well, you know, the last couple of popes named cardinal electors of such a number that it exceeded 120. So they were intending to dispense from it, but that's not an argument. You can't argue from the intention of John Paul II. He's dead. We can't speak to him. Nor can you do it from Benedict. He's dead. You can't speak to him. Can't do it from Pope Francis. He's dead. You can't speak to him. So that argument doesn't hold. It would have held if there was 121 or 122 in any of the past 3 conclaves. There wasn't. Because then you could say there was a custom. It was accepted. And the custom, because custom does establish law over 20 years. And it's been more than 20 years since 1996. Okay. It's been 29 years. So for all these reasons, their rationale in this declaration they made on April 30th is dishonest and fraudulent. But it's for even one more reason, because in their rationale they said, well, in paragraph 38 it says all the cardinal electors can vote. Well, you can't quote paragraph 38 to make a doubt rise about the application of a command in paragraph 33. Anyone who studies jurisprudence knows that in a law, the rules for the conditions of the law set at the beginning govern everything that follows. So in paragraph 38, the only authentic way to read that is that of the 120 cardinal electors, all have the right to vote. You can't say cardinal electors there means all the cardinal electors in the world, because paragraph 33 just limited it to 120. It didn't say all the cardinals in the world. So their rationale has no juridical force because all the cardinals weren't present when it was voted on. It makes a false claim. There is no dispensation granted. It makes a false legal argument claiming mere creation of cardinals after 1996 means a dispensation from the law, and that would be absurd because that would be saying They were being created for some other purpose, not to observe the law. Okay, and this fifth argument, where they're citing a section of the law that comes after the precept they're trying to do away with. It's not even necessary to say that your power to interpret a law doesn't mean you can cancel the law. Because if you allow 133 and not 120, even if they all met together and they were unanimous and they cited some other part of the law, where they didn't cite paragraph 38, it would be fraudulent because you're innovating the law. When you change a law, that's called innovation in Latin. Canon 335 expressly forbids the change of any law in the church during a sedevacante. And so the promulgatory clause of John Paul II declares this declaration of the cardinals irrita. That means we must consider it never to have been made. Which means when they held the conclave with 133, they violated number 68 of the law, which is actually part of the law they can't interpret because it has to do with the process of the election. In number 68, it says, once the cardinals vote, you count their votes. And if the number of ballots does not equal the number of cardinal electors who voted, you can't count them, you must burn them and do the vote again. So obviously, when it says cardinal electors in number 68, this is governed by the rule in number 33 that it's no more than 120. So when they had 133 vote, if they had taken 13 out by random and thrown them away, they could have counted it, because then there would have been 120 corresponding to the only 120 could vote. But they counted 133. And once they counted 133 ballots, they opened them up and saw who they were for. That violates Canon 68. They should have been burnt and no one should have seen what was in them. And that's true for the first, the second, the third, the fourth ballot. So this conclave couldn't have elected anyone validly. It ended without having any juridically valid result. Now, what I have said, anyone can contest if they like, but give me good reasons. Cite the sources of ecclesiastical right. Try to prove me wrong. Can't prove me wrong, then you have to share with me the opinion that this Leo XIV is not the Pope, because he has not been validly elected. We have, therefore, the right, and I ask you to share this video, share this analysis with every canon lawyer, every bishop, every priest in the world, and all the cardinals. Because since this election was invalid, that means Leo XIV did not receive the Petrine office from Jesus Christ. Because Jesus Christ said, whatever you bound on earth is bound in heaven. So the prescriptions of this papal law of John Paul II are written in heaven. Christ is going to follow them, even if the cardinals didn't know they violated the law. Because, as John Paul II, even if you didn't know you did something contrary to my law, it's still irrita, null and void. And it's not a crime or a sin. It's actually an act of virtue and honesty to tell our superiors the problems in the church, and to tell the cardinal electors, you got it wrong. You did it wrong. You got to do it again. Otherwise, you're going to lose your right to elect the Pope. Okay, because you have to be competent in doing this. If you're incompetent, we're going to be in a sedevacante. God bless, and thank you very much for listening.